what we see in his affidavit is an absence of methodology.
So it sounds a lot like it may just be a disagreement.
If it's just opinions and conclusions, that's for the jury. In the Karen Read case, has Judge Cannone had just about enough of the special prosecutor's attempts to boot out all the experts?
Was Green's methodologies debunked, or does the judge think it's just a difference of opinions? I'm Lainey Law.
And I'm attorney Andrew Myers.
And it looks like the judge is starting to change her mind in this regard, Andrew. Could it be that she's had enough hearings going on?
Well,
It's hearing after hearing.
I don't know. She's kind of put the parties in this case on a tight deadline in terms of filing a motion to dismiss, which is coming up. But we have to back up just a little bit and point out that, remember, Hank Brennan had filed a motion to knock out the expert Richard Green, the forensics analyst for Karen Read, who had testified that that famous "Hoss longed to die in the snow" did, in fact, occur at 2:27 a.m. in the pertinent day. And he said it was debunked. And
your favorite word?
Yeah, debunked, my favorite word. I don't like it when people say that something's been debunked because I don't know what it means. I think it just means that people disagree. But in any event, Hank Brennan got the opportunity to argue his motion. He claims that Richard Green, the forensic analyst for Karen Read, just doesn't, in his view, follow any accepted methodology.
And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession.
Well, all right. He was just getting.
I'm sorry to interrupt. I was just thinking, well, because your profession, you're a lawyer. You could also be a podcaster. You could do multiple things.
Well, and there are different types of lawyers, and I do different types of law. I mean, I've done criminal defense. I do personal injury. I do bankruptcy. I could say I'm a federal attorney because I've been in the federal courts. So, yeah, I mean, different people have different descriptions for what they do. And so he really went from there down to then saying that Mr. Green didn't have any methodology. He didn't have any methodology. He wasn't pointing out any methodology. Well, the Green affidavits that he pointed to are lengthy. We're not going to bore our viewers with the details of those 2. We're going to look at our document in a minute that summarizes that. But he just kept saying, no methodology, no methodology, no methodology. And does that ring a bell? Didn't we hear that repeatedly in the Daubert-Lanigan hearing for Dr. Russell?
Not only that, but also methodology, saying there's no methodology after there's a video that's mysteriously like not showing up and that there's seemingly no methodology for anything on the state side regardless. Not only familiar, but a little, I don't know, a little ironic, a little bit of a coincidence. I'm not sure.
Well, the generally new attorney for the Karen Read team, Robert Alessi, got up, and he had pretty much had enough of it. And he pointed out, hello, there's plenty of methodology here.
Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case.
By the way, all that paper rustling is in that court. I mean, there are open microphones. There are open microphones everywhere for the defense team, which you can see there on the right. The prosecution team had 3 or 4 lawyers, plus the bench. So that paper rustling isn't us. We don't want nasty comments on that. We get enough nasty comments, as
Oh
Lainey,
boy, yeah.
as Lainey will tell us in a minute. But here's, I shouldn't step on Mr. Alessi because he made a good argument.
And that is with regards to the search house long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue, after his testimony, any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution, after his testimony, stand up and ask for any such limitations or qualification.
And then Attorney Alessi went way down into the weeds of the affidavits, pointing out that not only did Richard Green use an incredibly detailed methodology, but it was the same methodology, which we're going to see in the document in a minute, the same methodology that was used by the Commonwealth's 2 experts. So it seemed that what was happening here was that the Commonwealth Special Prosecutor Hank Brennan doesn't agree with what Richard Green is going to say. He doesn't agree with the final conclusions. And you know what that is? That's a typical battle of the experts. And that is something for the jury to decide. Basically, what Lanigan and Daubert ask is whether the witness, the expert witness, is qualified. Do they have the background, the education, the training, the experience? And is there science that they're basing their testimony on recognized, peer reviewed? Do other people recognize that it's a reliable method of coming to a conclusion? And that was fairly clear in the first trial. You can say it has been debunked, but it seems to me, and correct me if I'm wrong, from reading what the judge Cannone said at the end, I think she's had enough and she might just not want this Daubert, because that's what this was all about. Mm-hmm. Should there be a Daubert-Lanigan hearing on Richard Green? Like, remember that 2-day hearing on Dr. Russell? And I don't know. You tell me if I'm reading too much into what the judge said at the end.
I thought we were going to be cutting down on people for this next trial. I thought that was going to be the big thing. And it looks like all the experts that were let in the first time are going to be let in the second time, hopefully. I'm assuming, if we didn't question them before, why are we suddenly going to backtrack and question them?
So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday.
So what she's saying there is, if it's just a difference of opinions, and obviously the prosecution and the defense experts are going to disagree. If that's all it is, that's an issue of credibility. That's a fact question. That's a question for the jury to decide. If she buys the methodology argument, then that could call for a Lanigan-Daubert hearing. But we're going to take a look at a document in a minute. But before we do, Lainey, am I reading too much into the judge's comment there, do you think?
I don't know. I personally, if I were on this case, would just want the retrial to start. Let's just get this over with. I mean, obviously she wants to give everyone their fair opportunity to speak, but, I think the prosecution is technically doing their job in the sense that they're going to fight against all these experts, but just do we need this? Like, get on with it. If they're using a good method. The thing is like this goes back to like my concerns with the police, where it's just like I trust that anybody with any like computer background is going to have some methodology and some step process to what they're doing technologically. I get upset when it's just everything's like a mess, but something like data retrieval, there has to be certain ways to do it. So it should
So
be
now,
very clear.
I hear you exactly, and I think that's a good point. A couple of weeks ago, we did an in-depth episode on the original motion by the Commonwealth, where they said that they thought that Mr. Green's theories had been debunked. So, in fairness, don't you think that we should look at the defense's response?
Let's see how debunkable they are.
Okay, so this is the defendant's opposition to the Commonwealth's motion to exclude certain testimony of the defense witness, Richard Green. And they're saying that the motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth.
Damn!
Don't you love that language? Don't you love that language?
That's a Gatling gun of language right there. Oh my
Really,
gosh.
the
Really pulling the
Gatling
heartstrings.
gun. Dystopian approach. By the way, when I was in college, I took a literature class, and you might not believe this, but my minor was literature. I took a class in the dystopian novel. Anyhow, the dystopian approach of the Commonwealth to deny Ms. Reed the ability to present her defense through her well-credentialed, methodologically reliable, you like that word, methodologically reliable expert witnesses, so she can have a fair trial against the baseless charges lodged against her. So that paragraph really summarizes this opposition by Karen Read's attorneys. The methodology that Mr. Green employed in the first trial was the same methodology that the proffered experts for the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone 1, verified the hash signature value of the image file, took the image file and saved it to their computers, servers, hard drive, etc., and then processed and evaluated the image file with the appropriate tools such as Celebrite Analyzer and Magnetic Forensics Axiom.
Hold on, an image file?
Yeah.
You can't make up different times for an image. That when you take an image, you take the image. It's down this. If that's what the certain like, if it's something like a screenshot, you can't. That's something that you can't go back and forth with. Anyway.
Well, while the Commonwealth witnesses Ian Whiffen used only the Celebrite Physical Analyzer and Artex tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using. If this isn't a battle of the experts, I don't know.
Oh my God, too many weapons, too many Gatling guns.
With Green and Hyde using 4 of the same tools, notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions in her previous reports that it is best to use multiple tools. Well, all right. Importantly, it was undisputed by all experts at the first trial that the 2:27:40 a.m. search artifact was indeed present on the iPhone of Jennifer McCabe after analysis using Celebrite Physical Analyzer forensic technology. You say that 5 times fast.
Oh my God, I really need to know what Celebrite is up to, because Celebrite seems to have all the deets and tea on this. Like,
Yeah.
the thing, because with data and information, it's so interesting that they can even be going back and forth like this, because I agree that it's important to use multiple tools. Like they said, you got to verify your results. But at the end of the day, like how much, when you're sending out a search query, that's recorded to a server, like history is going to have, that your phone's going to have, that are they doing it in incognito tab? If you're doing it incognito, that's a little suspicious, but at the same time, the network is still going to have that type of information. So like when we think of like every single search we do, we're not like if you look something up, Andrew, there is cookies out there saying that
Right.
this older gentleman is making this search at this
Oh, I
time
know.
relating to this interest, and they fall into these XXXNO category, and a million, there's so many different things. So this should be very clear, and it sounds like they were even as this is saying, agreeing on those methodologies, because it should be something that's transparent.
Is that kind of like geo-tracking where I go, I'm looking for new office computer printers because my old ones are just, as you know, they're just crap. So I go online, I go in Google, and I look for for new office printers. Then the next day I go on Facebook, and there's all kinds of ads for office equipment.
Exactly.
Yeah.
Well,
yeah.
and that's so many things too, because you mentioned like the geolocation is just like there's so many different elements, especially when the average person gets your phone, you're just saying yes and yes and yes to everything. But you're right that your phone is aware of even what buildings you're standing next to. Your phone knows if you were in the vicinity of like a Best Buy or something, especially
Oh,
like
yeah.
because we think about
Yeah.
like our location getting pinged when you're searching, like what network is receiving this information.
Yeah. You can't
So
run and you can't hide. Not
yeah,
anymore. No, they
our
know where you
phones, they know
are.
everything. Yeah.
Yeah, it is thus completely inexplicable. And here's a really important point in this opposition. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as and then more comprehensive than that of the digital forensics witnesses of the Commonwealth. It is the opinions and conclusions, not the methodology of the witness, that differ. But that difference is not a Daubert-Lanigan issue. And that's what the judge was talking about in the clip that we just played a few moments ago. If it's just opinions and conclusions, that's for the jury. That's for the jury. Then that means that everything that Richard Green has to say is admissible because qualified as an expert. It is subject to evaluation for credibility. Remember, we talked about the two steps that any evidence needs to go through in a trial. Step one, is it admissible? Is it relevant? Is it non-hearsay? Is it an expert who's qualified? That's whether or not the evidence goes in. That's the determination of what they call the gatekeeper, the judge. That's the first step. Once it goes in, then the second question, is it credible? Can this witness come on the stand and say what he says and have the jury buy it? So the whole crux of this opposition is right there in blue. It's the opinions and conclusions, not the methodology of the witnesses, that differ. That difference is not a Daubert-Lanigan issue. And I stress that because those were the words with which Judge Cannone left the hearing right there, saying that it sounds to me that it's the opinions, but Mr. Brennan, I will look into the methodology. So anyhow, this goes on and on and on and on. We're not going to read every word because we've already hit the high points, but there's more. But there's more. I hate when people say that. For 3 years, in this case, there's been no dispute over the methodology employed by the defense to address the issue of the 227 search artifact. On June 21st, 2024, Richard Green testified at the trial as a defense expert without any objection as to his qualifications or methodology. And that's what Attorney Alessi was saying in the clip we played a few moments ago. The use of digital forensic tools to analyze data on raw image. As he stated in that testimony, after receiving the raw image file of the data contained on Jennifer McCabe's iPhone 11, Mr. Green used 5 digital forensics tools to evaluate and analyze the data on the image file. And then
it says raw image file. I'm so interested on what that means. I'm assuming that this can't be a traditional image, that this can't be like no PNG, like JPEG. I'm assuming this I'm assuming this raw image file, and I can verify and look it up right now, but
I think they
Really-
imaged the data that was on her phone. I think that's what it means.
Yeah, that's what I'm thinking, is that it has, like, it's almost like a copy of the phone.
But look at all these
Unfortunately-
different forensics tools that he used. I didn't highlight it, but Celebrite Physical Analyzer, Magnet Axiom, Belkasoft X, Sanderson Forensics, SQ Light Forensic Explorer, and Arctex. Now, the first two, Celebrite and Axiom, we've heard of in the Koberger case, and many other cases too. Those are the two, kind of gold standard program. I don't know anything about this. I just know what I hear and read in these cases. And those are what appear to me, as an attorney, but a layman and all this technical stuff, to be the two key programs that are used for this. But, he used more. So the findings were consistent with the April 24th report of, get out the dun.
Uh-oh.
Trooper Nick Garino. Remember
Dun,
Nick Garino?
dun, dun.
So this is the other big thing from this opposition. This is the other major point from this opposition. Trooper Nick Garino, who missed a ton of emails on Jen McCabe's phone, but the findings were consistent with the April 24th, 2023 report of Trooper Nick Garino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Garino reported that while the 2:27:40 a.m. search artifact did not appear on the version of Celebrite Physical Analyzer he had used for his May 4th, 2022 analysis of Jennifer McCabe's phone, Mr. Green had used the then newest version of Physical Analyzer, which did depict the 2:27 a.m. search artifact. Inexplicably and unexplained up to this day, Trooper Garino did not disclose in his report of April 2023 that the Axiom program he used at that time did show the 2:27 a.m. search artifact. Isn't that amazing? Isn't that amazing?
Basically, what this is saying is that it did confirm that they saw it, that they saw the same thing. Yeah.
Nick Garino saw that the search "How Long to Die in the Snow" was made at 2:27 a.m. Conveniently, he never said that when he was on the stand. He never said that when he was on the stand in trial 1.0, which unfortunately appears to be leading to trial 2.0. But that's one of the major points in this opposition. And anybody that says that Mr. Green did not use methodology needs to read the innards of this motion. We're going to pass to the next really important thing. The only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green is that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensics data analysis. So if we follow this, what this means is that there will be another lengthy Daubert-Lanigan hearing in which not only will Richard Green go on the stand and be not only examined but cross-examined, and then examine again, then there'll be the Commonwealth's experts. So I'm guessing, I don't know, I never know what a judge is going to say or do because many of them have poker faces, but I'm going to think that perhaps the judge is thinking, I ain't going to do this again, not with Mr. Green.
Well, I'm surprised that they wouldn't play harder on this, because this is actually, it almost seems damning for the state in the sense where you have the remnants of this data and it's saying that it exists in the removed state. Or is the implication there that the search was made and they have evidence that suggests that there was an intentional deletion of that search and that's why, or whatever? So that is a really good point to stand on, where it's just like, why did we not hear about this before? Like, the state did not see this, but then also, why was this deleted in the first place? I feel like that's a really good point to build reasonable doubt from.
There's enough reasonable doubt in this case to drive a whole slew of 747's through. Okay. The Commonwealth additionally misses the point of a Daubert-Lanigan inquiry. It argues, for example, that Mr. Green's opinions as to the artifact containing the 2:27:40 a.m. timestamp lack any evidentiary support, cannot be made in good faith, constitute baseless claims, and have been debunked. These claims, in addition to being false, have no relevance to the methodology inquiry. They relate only to cross-examination and jury determinations. Here again, we get to the distinction between admissibility and credibility. And it can't be said enough, and that's what the defense is saying in this opposition, that, look, for all of these different reasons, a Daubert-Lanigan inquiry is a waste of time. Just let the experts on the stand, let them testify, and then let the jury decide. So this opposition goes through the standard for Daubert-Lanigan. We've talked about this before. It has a bunch of different points that have to be recognized, but we went through them when we talked about Dr. Russell's testimony. And when applying these standards, judges must be careful not to invade the province of the jury. And they cite a 1998 Massachusetts case. Critically, it's the qualifications and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. Differences of opinion present issues of credibility, which are properly reserved for the jury. Accordingly, expert witness testimony should not be deemed unreliable simply because there is a disagreement of opinion or in the level of confidence among the experts. It's almost like they're saying the same things over and over again, which is why we're skipping over a lot. You see a lot of white that we're skipping over in this, I believe, 24-page motion. As to the crucial inquiry of the Daubert-Lanigan standard, the proffered expert's qualifications, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensics technician and more than 18 years of experience conducting electronic data analysis and investigations. So they go on to point out not only that, but Mr. Green had testified in thousands of trials and had been qualified as an expert many times before. And that's what they're going through. And they cite a lot of case law. These are not the only errors of the Commonwealth making in its motion. For instance, the first footnote of the Commonwealth's papers is incorrect. Cellebrite is not the leading forensic data extraction software tool. Cellebrite is a company, one of the companies that provides one of the digital forensics tools relevant in this case. So,
damn.
If anybody's going to debunk anything,
he came at them for not using the Celebrate analyzer, the full name.
And bear in mind, this is just an argument over whether or not there should be a hearing. We took a look at the Commonwealth's debunk motion a couple of weeks ago. Now we're looking at the hearing that was held, and we're reading in fairness the defense's response to the Commonwealth's debunk motion. And so the determination for the judge right now is whether or not they should hold a hearing, which they were talking about doing it in a day, but I don't think so. I thought that Dr. Russell's hearing was going to be done in a day, but no, it took 2 days, two full court days.
Which in 2 days is crazy. And the thing is, it's just like, thankfully, I'm assuming most of our audience has never even been into a court. Imagine needing to stop everything you're doing for all these hearings on top of hearings. And then especially in this case right now with Green, where it's a tool that they can even both agree on.
Yeah, exactly. The Commonwealth's motion appears to stem not from a genuine dispute over Mr. Green's qualifications and methodology, but from its transparent and disquieting campaign to deny Ms. Reed the ability to present her own defense through her own qualified and reliable witnesses, to prevent the ultimate jury from receiving and evaluating evidence that is harmful to and inconsistent with the Commonwealth's theory of the case. and this is a point that's often made, I didn't highlight it, and to drain Ms. Reed of her resources in advance of trial in the process. So, you know,
Yeah, and I think that's another point to put where it's just like imagine anyone watching this, imagine you're put in this situation. Like how much money she has no resources left at this point after trial one. She's burning resources that don't exist. Like, oh, like this is for the state, it's just like we talk about like the state just gets, infinite amounts of money. This is a person that has to pay for these things.
well, I would remind you that the state only has an infinite amount of money because they've drained the taxpayers' pockets, which is why so many people have moved out of Massachusetts to other states. And there was some interesting news in the news this week, but I digress. That's not part of our legal analysis here. So the conclusion of this motion is, or opposition, I should say, is for the above reasons, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion to exclude certain testimony of defense witness Richard Green and its included request for an evidentiary hearing. So I would say the judge has an easy out by just, denying the Commonwealth's move to have a Daubert-Lanigan hearing, because the first one didn't really help them that much. Took 2 days. They got a chance to, do a dress rehearsal of how they're going to, take aim at Dr. Russell. And it just seems to me that that's all this is all about. Let us take a practice run at Richard Green and see how he does under our, cross-examination, which is, I shouldn't even say that, but it's just.
Well, I mean, it's just like, they didn't watch the first hearing. Brennan wasn't caught up with the first trial. So instead of, he's going to simultaneously watch that as he tries his own version of it. It's just like, okay, well, you know what? They didn't do this. Let's try doing this. Like,
it's nuts. Now, there were a couple other things that came out of the hearing in the court, and I got to refer to my notes because the judge is really pushing. Remember that little footnote that we talked about in a previous episode where the defense is saying, we are going to file a motion to dismiss this case based on some of the funny business here. The judge said, I want you to do that right away. And the defense pushed back. We don't have all the information. So the Commonwealth said, we will get all of our discovery out by next Wednesday, the Wednesday after we're recording this episode. And so Attorney Jackson said, we need time to put it all together. And the judge gave him till the following Monday. I want that motion by the following Monday. Mm-hmm. And if need be, we'll have a hearing on it the week after that. So that is really, she's really pushing them. She's really pushing them, and she has now a February 21st deadline for filing of all evidentiary motions, which means, some of these motions are just, I think the judge is getting as sick of it as we are. I didn't say that.
Oh my gosh. I mean, even February, we got to remember 2025 is creeping up on this. By the time you're watching this at home, it's February. It's coming up.
Yeah.
It's right around the corner.
Now, Gretchen Voss was in the court hearing a slightly different issue. Remember that the Commonwealth brought a motion to get all of Gretchen Voss's recordings and notes and everything else. And Gretchen Voss from Boston Magazine, who wrote that long article about this case, was in the court, and her attorney argued, we have turned over everything, the recordings and everything like that. But her personal notes should not have to go to the court and to the parties. And he made an impassioned, lengthy argument about, freedom of press, how this really does, as a former reporter in full disclosure, this does chill freedom of expression, but it also takes tools away from reporters. If a reporter is talking to a source and tells that source, you can talk in confidence to me. This is off the record. We're not going to record it. Just tell me, off the record. If a reporter makes that promise to a source and then that's reversed and they have to turn over their personal notes to a court, not only is it a chilling effect on freedom of speech, it also really punches the reporter in the face. I could use some other analogies, but that's the best one that YouTube will let me say.
Who's going to say anything anymore if anything you say off the record is still able to be brought up in court, you know.
So the judge took that under advisement. She wants to see those notes, and she will entertain motions to redact certain portions. So that's still up in the air. But that's pretty much it for this particular episode. We wanted to point out to people that we have another country in our World is Watching feature. Every week we tell people that, yes, the world is watching this case. And we have another new country this week. South Korea is on the list. And so now there are 45 countries from whom we have received comments. And we love your comments. We read them. And Lainey reads them. I read them. And sometimes they're great. And other times they go another direction. But we have now, don't let anybody tell you that the world is not watching the Karen Read case, because we have received comments, a lot of times multiple comments from some of these countries, like UK. People have repeatedly sent us different comments. And I don't know why Australia and New Zealand often send us comments. And I find that interesting that down under, they're following this case so closely.
Because what's going on where they live is probably so peaceful. I mean, other than like kangaroos and like, I don't know, tarantula attacks and other weird animals flying out the bats. Like, what are they doing in Australia? I mean, you know, thankfully, maybe there are some pretty crazy stuff going on right there that I don't know. But thankfully, you guys are not in the news as much as this case for your benefit. I hope. Hopefully everything's going great. If there's anything chaotic going on, let us know. But I'm assuming that everybody's just in disbelief. This is, you know, maybe this is a little Americentric, but I feel like you don't hear about this much craziness from other countries. This is, you know, there's always some type of craziness going on. I mean, obviously, and, you know, welcome South Korea to the list. You guys are still going through it. So I guess there's crazy stuff going on everywhere. But it doesn't, I think this case really leads into like a lot of people's fears that they can't trust the people that are meant to protect them. And that's really sad.
Well, one of our commenters last week had commented that they're in the UK and they follow all of our cases here in this country. The whole, like, there's at least a dozen hot true crime cases that are on the list right now. And the guy from the UK said, you know, we follow you because we can't here in the UK. The press is allowed to cover the original crime and the original arrest, but then we don't hear anything until the trial, because over there, and again, we left King George and that country for a reason. Over there, they don't have the freedom of press that we have here, and they don't have, you know, we wouldn't be allowed to look into the gesticulations. I've on numerous occasions complained about the fact that things in the Koberger case have not been very public. Well, we wouldn't even have what we have in that case in the UK. So anyhow, did you have some comments that you wanted to tell us?
Yeah, so I pulled some comments from one of our most recent videos on the Karen Read case. We actually did this with Mark Betterow. So I do want to say thank you so much to Attorney Betterow for joining us on that episode. But this is some of the comments you guys had to say, starting with JT Tomps. This case is butchered beyond repair, but the prosecution continues. They are not doing it on behalf of the people. They are doing it for the corrupt officials involved. And that just feeds back to what I was saying before about a lot of people are just in shock that you have these figures that are meant to be the ones protecting you. And now people don't know what to believe because there's so many issues. They can't even agree on where they're getting their forensics data from.
From Danielle Kumo. Hope I said that right. At this point, it seems the Commonwealth is either unbelievably criminally incompetent or so corrupt and arrogant that they think the laws and rules just don't apply to them. The special prosecutor should buy a one-way bus ticket and get as far away from this thing as he can. I just read them. I'm not saying yes. I'm not saying no. I just read them. This is the kind of thing that our nicer commenters say.
These are the nicer commenters, yeah. And yeah. So this is from Linda Ramirez, great trio, especially with the younger hosts in the mix. Oh, this one was cracking
That's
me
you.
up. You get experience along with the fresh perspective, i.e., her computer science background, and how her explanations are helpful with the immense use of digital evidence used in cases nowadays. I didn't put the other comment, but there was another comment that's like, "What does Lainey do?" And I gave like a very
Right.
thorough explanation. So when I saw this one like gassing me up, I'm like, damn, this person saw that and really wanted to make you feel appreciated. So thank you, Linda.
This is Ray Marshall. Ray Marshall, let's be honest for a second. Considering the absolute train wreck that the first trial was, neither the judge nor the prosecution will willingly allow this case to be dismissed. They will force it through, try to shoehorn a guilty verdict from the jury, and it will have to go to appeal. Then, of course, they will all pretend that they're so innocent and it was a simple mistake. Ugh.
What happens if there's no agreement?
What do you
Again,
mean?
if the jury doesn't agree, what if the jury
Oh,
disagrees?
if there's another mistrial, well, then the Commonwealth has some serious thinking to do, because in a typical normal case, which this is not, after a mistrial, based on just the cost, both financially, emotionally, just the time out, after a mistrial, usually prosecutors will offer a plea deal. But as we've said before, Karen Read will not take a deal. That's not going to happen. So, this is kind of a dark, literally comment, but I have a sneaking suspicion that sentence is correct, is that a motion to dismiss is coming up and a lot of valid points will be made, extremely valid points, but it's not going to be allowed.
Right. So, Robert's Cown. Of course, they had to destroy the video. It showed too much doctoring of the taillight, corruption by the police. And like Andrew said before, we are just reading these comments. These are just what people are saying. We don't agree or disagree with this. But the fact that they're having these issues with the videos in it's such a sensitive situation where it should be easily accessible.
Before we move to the next, I'm sorry, I stepped on you. Before we move on to the next comment, I neglected in my intense focus on the issue of Hank Brennan's motion about the debunked expert Richard Green, and our focus on that in this episode. I failed to mention that about 3 days before we are recording this episode, the Commonwealth dropped some additional discovery. And one of the points in their discovery was, here is the video of the Sally port, which we've already produced once before. So apparently we will need to find out what is in the video that was produced 2 or 3 days before we're doing this episode. Is it in fact the original? I would think that a forensics person would be able to look at it, look at the hash, look at the data, and determine whether it's an original, whether it's some kind of an edit, a dub, something they fooled around with. But so I just had to interject that thank you, commenter, for letting me get that little nugget of news in there.
And you make a good point with they'll be able to tell if it's the original or what, because like this whole point of the episode is that your phone has a certain data, it records your tasks. You can't really delete something. The space from when you delete something is still empty space. So and this is something that people may have seen on like Instagram, if you I don't know if they still do it, but if you upload a picture that used AI, it used to say like this image uses AI. Like you can usually see like the origin of the file in certain metadata that you wouldn't expect as just the average consumer. So they should be able to tell where the original data came from, and if it, if it's been altered, then it'll look like it came from somewhere else. So just to build off of what you were saying. So
Kathy B. Oh, is it your turn or my turn?
This is the last comment. Let Kathy, you read it.
Kathy Venus, I hope I said that right. All of the Commonwealth side are all in this together. Lies so corrupted I am. Okay, all right. I read it. I don't endorse it. I don't not
These are
endorse
his co-workers.
I just read it. That's all. But that's a common theme, how people feel about the case.
And the thing is, it doesn't even matter. Like, obviously, we've seen some bad behavior from like Proctor, but it doesn't matter like what people's intentions are at this point. The main issue at hand is just that people have distrust. So we're not saying that these people are one way or another, but the fact that everybody thinks that these people are intentionally doing bad things is concerning for society as a whole, in my opinion.
Okay, before we go, why don't we always have to have a question at the end, and I'm going to ask our viewers whether they think that the motion to dismiss, based on the things we talked about in our previous episode, will be allowed. Will the motion to dismiss the case be allowed?
Oh gosh. So answer that question down below, and be sure to have a wonderful day, guys. Thank you for watching this video. Answer Andrew's question down below. Leave your favorite emoji. We'll leave it up to interpretation, and be nice. And you see, we don't delete everything. We're trying to be unbiased, and you guys have a lot to say, so thank you.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.